Cplr disclosure. 3101. Scope of disclosure. A. Generally, there shall be full disclosure of all matter material and necessary in the prosecution or defense of an action, regardless of the burden of proof, by 1. A party or the officer, director, member, agent, or employee of a party. 2. A person who possessed a cause of action or defense asserted in the action. 3. A person about to depart the state or without the state, or residing at a greater distance from the place of trial than 100 miles, or so sick or infirm as to afford reasonable grounds of belief that he will not be able to attend the trial, or a person authorized to practice medicine, dentistry, or podiatry who has provided medical, dental, or podiatric care to the party demanding disclosure, or who has been retained by such party as an expert witness. And 4. Any other person upon notice stating the circumstances or reasons such disclosure is sought or required. Disclosure is sought or required. B. Privilege matter. Upon objection by a person entitled to assert the privilege matter shall not be obtainable. C. Attorney's work product. The work product of an attorney shall not be obtainable. D. Trial preparation. 1. Experts. A. Upon request, each party shall identify each person whom the party expects to call as an expert witness at trial, and shall disclose in reasonable detail the subject matter on which each expert is expected to testify, the substance of the facts, and shall disclose in reasonable detail the subject matter on which each expert will be testifying and their opinion, the qualifications of each expert, and a summary of the grounds for each expert's opinion. However, where a party for good cause shown retains an expert in an insufficient period of time before the trial to provide the notice required by this paragraph, he shall not be precluded from introducing the testimony solely on the grounds of non-compliance with this paragraph. In that instance, upon motion of any party or sua sponte, the court may make whatever order may be just. In an action for medical, dental, or podiatric malpractice, a party may omit names of the experts, but shall be required to disclose all other information concerning such experts as required by this paragraph. So in an action for medical, dental, or podiatric malpractice, any party can serve on the other parties, and like they call it an offer to disclose the name of their expert. And they can serve this thing. Okay, and if they're doing that, they're also offering to disclose the name and to make the person available for an oral deposition. Within 20 days after service of that offer, each other party shall respond to the offer, basically, and either accept it or reject it. If they don't respond, it's deemed a rejection. But if they accept it, they got to produce their experts too. So in an action for medical, dental, or podiatric malpractice, any party can serve on the other parties, and like they call it an offer to disclose the name of their expert. And they can serve this thing. There's like 2 20-day rules in this one. Okay, and if they're doing that, they're also offering to disclose the name and to make the person available for an oral deposition. Within 20 days after service of that offer, each other party shall respond to the offer, basically, and either accept it or reject it. If they don't respond, it's deemed a rejection. But if they accept it, they got to produce their experts too. So the way this works is a party serves this, they have to serve it and file with the court this offer to disclose the name of their expert in a dental malpractice or podiatric malpractice action. And then the other parties can serve and accept the offer within 20 days after service. If they don't respond, it's deemed a rejection. So you can either accept or reject the offer or ignore it, and that's deemed a rejection. And the only way this works is if everybody accepts the offer and then everybody's expert is available for a deposition. And they're disclosing the names and they're available for a deposition. But normally the exception to... So basically, if you accept the offer, you are required to produce your expert for a deposition. And this is a very serious penalty here because it says if any party having made or accepted the offer fails to make their expert available, they're precluded from offering any expert testimony at trial. So if you make the offer or you accept the offer and then you do not disclose your expert or make them available, you're precluded from offering any expert testimony at trial. This one I'm unfamiliar with, so I'm just going to have to read it. Cplr. Further disclosure concerning the expected testimony of any expert may be obtained only by court order upon a showing of special circumstances and subject to restrictions as to scope and provisions concerning fees and expenses as the court may deem appropriate. However, a party without court order may take the testimony of a person authorized to practice medicine, dentistry, or podiatry who is the party's treating or retained expert, in which event any other party shall be entitled to the full disclosure authorized by this article with respect to that expert without court order. I guess if you're going to take the testimony of that expert, any other party shall be entitled to the full disclosure authorized by this article with respect to that expert without court order. Materials. 2. Materials. Subject to the provisions of paragraph 1, materials otherwise discoverable under subdivision A and prepared in anticipation of litigation or for trial or by or for another party or that other party's representative, including an indemnitor, agent, insurance, or insurer, consultant, survey, or agent, may only be obtained upon a showing that the party seeking discovery has a substantial need for the materials and cannot, without undue hardship, substantial need of the materials in preparation of the case and cannot, without undue hardship, obtain the substantial equivalent by other means. In ordering discovery of the materials, when the required showing has been made, the court shall protect against the mental impressions, conclusions, opinions, and legal theories of an attorney. E. Party statement. A party may obtain a copy of his own statement. F. Content of insurance agreement. An insurance agreement is discoverable, and for this reason is not admissible evidence at trial. An application for an insurance policy is not considered part of an insurance agreement. I guess they don't want, you to be able to say to the jury, my client should just get his money because he had a $20 million insurance policy. G. Accident reports. Accident reports are subject to disclosure. There shall be full disclosure of any written report of an accident prepared in the regular course of business operations or practices of any person, firm, corporation, association, or other public or private entity, unless prepared by a police or peace officer and it could interfere with a criminal prosecution. So we had to prepare it in anticipation of criminal prosecution and being used for that purpose. And the investigation or prosecution, it would interfere. H. Amendment and supplementation of responses. A party shall amend or supplement his response previously given to a request for disclosure promptly upon the parties thereafter obtaining information that the response he gave was incorrect or incomplete when made or that the response, although correct and complete when made, is no longer correct and complete, and such that a failure to amend or supplement the response would be materially misleading. Where a party obtains information an insufficient period of time before the commencement of trial appropriately to amend or supplement the response, he shall not be precluded from introducing evidence at trial solely on the grounds of non-compliance with this paragraph. In that instance, upon motion of any party or sua sponte made before or at trial, the court may make whatever order may be just. Further amendment or supplementation may be obtained by court order. I. In addition to every other matter that's discoverable, there shall be full disclosure of any films, photographs, videotapes, or audio tapes, including transcripts or memoranda thereof, involving a person referred to in paragraph 1. So that was the attorney, agent, employee of a party. There shall be disclosure of all portions of the material, not just what you want to use at trial. There's also the law enforcement exception in here, and what it says, the provisions of this subdivision shall not apply to materials compiled for law enforcement purposes, are exempt from disclosure under the public officers law.